Ms. St. John, what's a universal injunction?
Universal injunction refers to an injunction that applies universally beyond the parties to the case.
The Supreme Court has recently had something to say about universal injunctions, has it not?
Yes, Senator.
What did the Supreme Court instruct us?
Well, in Trump v. Casa, the Supreme Court held that universal injunctions are disfavored and courts are limited to awarding complete relief as to the parties before the court.
Did the Supreme Court talk about class actions in its opinions?
No, Senator, not directly that I recall.
Okay. Do you think one of the arguments, as I understand it, for universal injunctions, well, it's both an argument for and against, but that it impacts more than just the plaintiffs before the court. Is that correct?
Yes, Senator.
I've heard the argument made that a substitute, some would argue a more efficient substitute for universal injunctions would be a class action lawsuit. What do you think about that?
You know, a class action does allow relief beyond the named representative plaintiff. The class actions have a lot of additional safeguards set forth in Rule 23. And so, it does allow large groups of plaintiffs to come together in one case in a way that may not be, to seek relief in a way that bilateral litigation may not allow, but it does have additional protections.
Okay. Let me go back to Mr. Davis. Since we have our ATF nominee in front.
The exchange today sounded technical, but it cuts straight to the heart of how much power a single judge should have over national policy. Senator Kennedy pressed a judicial nominee on the meaning of a universal injunction, a legal tool that can freeze a law or executive action not just for the people who sued, but for everyone in the country. It is one of those courtroom concepts that rarely trends online, yet it can stop presidents, agencies, and Congress in their tracks with a single ruling. At its core, a universal injunction is a court order that reaches far beyond the specific dispute in front of a judge. Instead of resolving a case for the actual plaintiffs, it blocks enforcement of a policy nationwide, even for people who never stepped into the courtroom. The Supreme Court has grown increasingly skeptical of this practice, signaling that judges should generally limit relief to the parties before them. The alternative often raised is class action litigation. The court is right to be cautious. Universal injunctions may feel efficient, but efficiency is not the same thing as legitimacy, especially when one judge can effectively make nationwide policy overnight. Class actions are slower and messier, but that friction is a feature, not a bug, because it forces courts to verify who is affected and why. When the stakes are national, the process should be careful, transparent, and grounded in the limits of judicial authority.